Hi everyone, I'm Jeff Green from the Mitchell Center, welcoming you back to our next panel from our Campus Speech Battles Conference. We really look forward to having Nadine Strossen and John Powell be our next set of guests on the upcoming panel right now. But before we turn to them and our moderator, Sigal Ben-Porath, let me just thank our co-sponsors for the conference, the Penn Graduate School of Education, the SNF Paideia Foundation, and the Jack Miller Center. And let me give you all a sense of what is coming down the pike after this afternoon's event. Our conference on campus speech battles will conclude next Tuesday evening, the 29th, from 5 to 6:30 p.m. with Joan Scott from the Institute for Advanced Study and Jasmine Banks from Uncoke My Campus. And they'll be speaking on the topic of academic freedom and student activism. This conference that we're having, Campus Speech Battles, is part of a year-long series of events at the Mitchell Center on the topic of free speech battles. And we have your email addresses and we'll be able to update you about the 6 or 7 more events that will be happening over the academic year. But let me draw your attention to what's coming right after the conference in October. We have 2 events that we're very excited about. On October 13th, Mark Thompson, the CEO of the New York Times from 2012 to 2020, and also a scholar on topics pertaining to political discourse, will be giving his reflections on the independent media in America and elsewhere, what's causing it to come under stress and what might be done to protect it in this turbulent moment. And then at the end of the month, on October 29th, we'll be having at the Mitchell Center Derrick Black, who is the son of Don Black, the founder of a pretty sizable white nationalist website, Stormfront, but who came, Derrick Black, to renounce his father and his family's white nationalist ideology. And we'll be inviting him here to talk about hate speech and, based on his own experiences, what he thinks can be done to overcome it. The events that are coming for the rest of the year and the events that make up this Campus Speech Battles Conference have all been planned by a planning committee, which includes Joe Lowry, Sophia Rosenfeld, Amy Sepinwall, Takufu Zubieri, and Sigal Ben-Porath, our moderator for this afternoon's event, all of whom are my colleagues here at Penn. As I turn things over to Sigal, let me just say that she is so well situated to be our moderator for this set of panels at this conference. She herself is a leading scholar on matters pertaining to free speech on campus, and that's the title of her 2017 book, Free Speech on Campus. And she also served as the chair of Penn's Committee on Open Expression, which dealt with a variety of free speech issues at Penn's campus over the last few years. She also serves on the board of the Mitchell Center. And over the years that I've worked at the Mitchell Center, I've had many opportunities to consult with her on our own events that have had to deal sometimes with open expression issues. And I know from these conversations how I've come to appreciate her tremendous expertise on the topic of academic free speech, the wisdom and generosity of her advice, and also her clear sense that there is more left to be discovered and understood about the proper norms and ethics of free speech on campuses, and thus her deep commitment to the academic study of speech in a forum like the one that she's leading today. And so thank you, Sigal, in advance for this discussion. Thank you, Nadine and John. I'll turn things over to you.
Thank you so much, Jeff, and thank you for the opportunity to really organize all of these events through the Mitchell Center this year. I'm especially excited about this event that we're having today, and I'm grateful to our 2 speakers who I will introduce now for giving us their time and their expertise to think with us or continue thinking with us about these important issues. So Nadine Strossen has written, taught, and advocated extensively in the area of constitutional law and civil liberties, including through frequent media interviews. From 1991 to 2008, she served as the president of the American Civil Liberty Unions, the first woman to head the nation's largest and oldest civil liberties organization. Professor Strossen is currently a member of the ACLU National Advisory Council, as well as the advisory boards of the Electronic Privacy Information Center, the Foundation for Individual Rights in Education, or FIRE, Heterodox Academy, and the National Coalition Against Censorship. So she's very committed to the public leadership of freedom of expression issues. It's interesting to note specifically today that when she stepped down as ACLU president in 2008, 3 Supreme Court justices participated in the farewell tribute that the ACLU held for Nadine Strossen, and they were Ruth Bader Ginsburg, who is lying in state as we speak, Antonin Scalia, and David Souter. So feels like different times. Professor Strossen has made thousands of public presentations before diverse audiences, including on more than 500 campuses and in many foreign countries, and has commented frequently on legal issues in various contexts. She has too many honorary degrees and awards to list here, so let me just note that at the NYU Law School's 2019 commencement, Nadine Strassen attained the unique distinction of winning both the award for outstanding teaching and the award for the best book. She has written for years about free speech, including, for example, in her earlier book, Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights. But more recently, in her 2018 book, Hate, Why We Should Resist It with Free Speech, Not Censorship, she writes, and I quote, "To be sure, campuses and other arenas in our society must strive to be inclusive, to make everyone welcome, especially those who traditionally have been excluded or marginalized. But that inclusivity must also extend to those who voice unpopular opinions, especially on campus, where ideas should be most freely aired, discussed, and debated. Encountering unwelcome ideas, including those that are hateful and discriminatory, is essential for honing our abilities to criticize, to analyze, criticize, and refute them." And Nadine will be in conversation with John Powell, who is professor of law and professor of African American Studies and Ethnic Studies at Berkeley, where he's also the Robert D. Hass Chancellor's Chair in Equity and Inclusion. John Powell is an internationally recognized expert in the area of civil rights and civil liberties and a wide range of issues, including race, structural racism, ethnicity, housing, poverty, and democracy. At Berkeley, he's the director of the Othering and Belonging Institute, which supports research that can help address disparities related to race, ethnicity, gender, sexual orientation, disability, and socioeconomics in California and nationwide. Previously, he was the executive director of the Kirwan Institute for the Study of Race and Ethnicity at The Ohio State University, where it's a national leader on research and scholarship related to race, structural racism, and opportunity. And prior to that, Professor Powell was National Legal Director at the American Civil Liberties Union, where he was instrumental in developing educational adequacy theory, which I regret that we won't have time to discuss today probably, but is also a very important contribution. Professor Powell has written extensively on the issues that I mentioned, including voting rights, fair housing, affirmative action in the United States, South Africa, and Brazil, racial and ethnic identity, spirituality, and social justice, and the needs of citizens in a democratic society. In his most recent book, Racing to Justice, Transforming Our Concept of Self and Other to Build an Inclusive Society, he writes, and I quote briefly, "Justice involves claiming a shared mutual humanity. It is about interrelationships. Thus, the problematic and isolated white self forms the backbone of resistance to a truly robust, inclusive America and energizes much of the conservative movement." And I'm skipping a small part here and continuing. "We cannot expect people to expose themselves to ontological death or worse. Instead, we must provide space, institutional space, political space, social space, and conceptual space for the emergence of new relationships and a new way of being that exists beyond isolation and separation. So I'm very excited and looking forward to the exchange between Professor Strossen and Professor Powell. I'll just make a quick procedural note before we start the discussion. So the Q&A function is open and everyone is welcome to start using it at any moment that they so choose. We have a couple of Penn classes in attendance today. If you are a student in Professor Seppin-Wall's Legal Studies 221 or in Professor Rosenfeld's History 133, or if you are a Paideia Fellow, please identify yourself as such when you are asking a question through the chat function. And after the initial conversation between our speakers, we will open up for discussion, which will start with student questions and then move to general audience question. But everyone is welcome to submit their questions at any point in time. So I thought, Nadine and John, that we can start our, or you can start your conversation by thinking about the broad issue that I think we can distill from the conversation or the panels that we had so far in this conference, where we heard from Howard Gilman, Sari Banks, and Jeffrey Stone. And one of the things that came up repeatedly in discussion was the question of whether the First Amendment and the principles that protect free speech and open expression should be understood as definitive and standing, resolved in their understanding and application, or if they should be understood as open to interpretation over time, and particularly as standing in on a spectrum that includes, on the other hand, inclusion and equity that should balance out the way that we understand open expression. There are a few other questions that came up, which I can also offer to you, but I thought maybe you could start with attending to this general question, and I look forward to hearing your thoughts.
Don, you should start this one, please.
Well, first of all, thank you, University of Pennsylvania, and all the other panelists. It's always a pleasure to be in conversation with Nadine. You know, we have tremendous agreement, really wonderful, a long friendship. And then we have things we, you know, challenge each other on, but hopefully respectfully and learning. So I think the question, and I think we'll come back to this many times, is really quite complex. Part of it, and I just said this recently to some colleagues here at Berkeley, that we don't teach the philosophy of knowledge anymore, or the history of knowledge. So we think of it as just a thing, as opposed to it's embedded in a bunch of other systems and structures. I'm reminded when I hear the question, and I studied philosophy a long time ago. Me and Plato were friends. But in all seriousness, people will remember the Greek concept of trying to find something that was fixed. And this was done by Archimedes. And so it came to be known as the Archimedean point. Find something that doesn't move. Find something that stands above and beyond the rest of the universe. Find something that's completely transcendental. Of course, he wasn't successful. He looked his whole life and was not able to find such a thing. And so whenever I hear the admonition to find something that's absolute, I always think back to the Greeks. There's very little to suggest that there is such a thing. And I would say that's a kind of hubris that you want to, some people call it the God's eye view. It doesn't mean that everything has the same valence or changes at the same time. We only have to think about our Constitution. No, that's not true. But we also think about our Constitution as a living document, and that it's constantly being applied and thought about in different contexts. And it's not just the application, it also causes us to rethink what something means. You only have to think about something like the opinion in the marriage equality case. You know, obviously the framers didn't think about marriage equality when they thought about the 14th Amendment in terms of gay and lesbians. Is it wrong then this is extended to gay and lesbians? And even the citing of the UN, The UN didn't exist when the framers were alive. So I think to two things. I think it can't be absolute. In my mind, virtually, I think we should be very critical and skeptical of anything that claims the mantle of absoluteness. It starts to lean very much into a kind of religious fundamentalism. Having said that, I think certain things have more gravitas than other things. And I certainly think speech has that. But I think it's in conversation with a number of other things, and it has to be, both to give it meaning and also to make meaning of the large society. And you suggested some of those things. I'll punt for now, but I go back to Lincoln's Gettysburg Address. And I do that because, first of all, it's very short, very pithy, which doesn't happen much anymore. And I guess I'm violating by going on too long. But secondly, Lincoln was very clear in 1863, basically saying that the Constitution was flawed. And he talked about 7 years ago. What had happened 7 years ago was not the Constitution, was the Declaration of Independence. And he was saying, by reference and by omission, that because of the Constitution's refusal to grapple with equality, and by extension slavery, it was flawed, and that we need to really refer back to our founding document, in his mind, the Declaration of Independence, and incorporate equality into our society. And in a sense, he was also saying that equality and liberty were, in a sense, two wings of a bird. They're needed together. And we had actually sacrificed and the understanding of equality. The last thing I'll say for now is that I think that's right. What Lincoln was trying to do, and he called for a new birth of equality, a new birth of liberty at the end of his address, and calling forth our better angels. Both concepts, liberty generally and free speech more specifically, on one hand, and equality on the other hand, are really complex concepts. They're not a single concept. And I wrote something about this recently. Just think about the fight around wearing a mask or not wearing a mask. And people frame that in terms of, I have a right, a personal right, not to wear a mask. You can't tell me to wear a mask. You're violating my freedom. And then when you being a little bit of a nerd, go back and look at equality is a very complex concept, set of concepts. It's not a concept, it's a set of concepts. Liberty is a very complex set of concepts of freedom. And there's a freedom that's personal that should not be infringed upon without a great deal of overcoming certain assumptions. But there's other freedom that's, in a sense, social freedoms or liberties that that we actually don't think about much anymore. And so this is partially Mills when he talks about individual liberty and social or utilitarian liberties. And individual liberties is what some people refer to as self-regarding, the things that don't affect other people. And social liberties or utilitarian liberties are liberties that are not the liberties that impact other people. So a quick example would be driving a car that's spewing things in the atmosphere that's affecting climate change. So do I have a right to drive a car? Mills would say, from this perspective, I don't have an individual right. If I have a right, it's a social right, a social that's given to me by some social calculus and other people being involved. And so going back to wearing a mask, if not wearing a mask can harm other people, I can't claim my individual right is not to wear a mask. And I still argue that I shouldn't have to wear one, and we can have that discussion. So again, what that suggests to me is that we're dealing with a lot of complex concepts, and we understand some things that we didn't understand before. We're in a different world. And so is there such a thing as absolute free speech? I'd say no. How do we then deal with that? It's complex, and I think we started that discussion from my perspective, somewhat late. I think Nadine has contributed a lot to that discussion. But we haven't really, from my perspective, embraced it deeply enough. And when we do embrace it, we almost always start with putting free speech at that Archimedean point, and then what's left over, we're willing to talk about in terms of equality. And going back to Lincoln, I would say that's a mistake.
Thank you so much, John. It is always such a treat to listen to you and to learn from you on a much more mundane level, because your philosophical principles are so important and I believe are reflected in the Constitution. But let me turn much more mundanely to the Constitution itself, because I think the framers, you used the word hubris, that is what we are to avoid. What we should seek and practice instead is humility. And I think that the Constitution reflects the framers' humility about their inherent limitation and flaws as human beings. Among other things, they used very broad language in the important provisions, including the First Amendment, which after all was an amendment. Let's bear that in mind. Not to mention the 14th Amendment, which was an even later amendment. But when both of those amendments were added, they included really open textured language, freedom of speech and of the press, equal protection of the laws. When you contrast that open-ended language to many other provisions in the Constitution that are so specific, to cite some well-known examples, how old you have to be and where you have to be born and where you have to be residing to be eligible to run for President of the United States, it's very clear that they made a calculated choice to leave some passages open textured, with the humility to recognize that there will be changing circumstances. And as the early renowned Chief Justice John Marshall said, it's a Constitution intended to endure for many, many years into the future in changing circumstances. The other historical humility that they clearly embedded in the Constitution itself was Article 5, allowing for an amendment process. Sadly, there were a couple exceptions. That's a discussion for another day. But basically, they wanted to provide a mechanism for the correction of errors that, quite frankly, all of them knew, right? This was a compromised document. So everybody, even at the time they signed it, was aware of some deep flaws and errors. And it's interesting, if you look at the amendments that have been added to the Constitution over time, the vast majority of them have been for purposes of extending liberty and equality to groups of people that were not originally included in the original concept of we the people, to quote the opening words of the Constitution. So I think the framers themselves could be a wonderful object lesson. We know that they were flawed, but with 2020 hindsight, we have to ask what our future generations going to look back and see as the flaws, that what are our blind spots. Now, with respect to the First Amendment and equality, I very strongly believe that they are, yes, I agree with John, each one is very complex, but ultimately I believe that they are mutually reinforcing and independent, that we cannot have meaningful liberty, including freedom of speech, unless there is equal opportunity to exercise that speech. And I would even go beyond that. And this is one way in which my thinking has evolved, thanks in large part to what I've learned from John and what I've learned from Segal. Segal has coined this wonderful phrase that I think has now just entered the lexicon, inclusive freedom. If everybody doesn't have access to the resources and the wherewithal and the education and the information to make effective use of free speech, that's not real free speech. I think it's so interesting, and if you go back and look at the great movements for equal rights in our country's history, so many of them marched under the banner of freedom, right? That was the banner during the civil rights movement. They understood that they were seeking meaningful freedom, which had been denied on the basis of who you are. Same thing we used to call in the 60s and 70s, refer to the women's liberation movement. Same thing with the struggle for gay rights. So these two are indivisible and interdependent, and that's actually the First Amendment doctrine itself recognizes that freedom of speech is never absolute, but can always be overcome. And John you went in this direction, John, when you said there's a very strong presumption in favor of liberty and against government power to restrict it. But government that government may restrict speech if that restriction, and here this is going to sound familiar to those who have studied constitutional law. I'm about to recite the standard for so-called strict scrutiny. If the government can show that the restriction is necessary to promote a goal of compelling importance. Clearly, equal opportunity and countering discrimination on the basis of race, gender, religion, and so forth is a goal of of compelling importance. And if there were a speech restriction that were necessary to promote that goal, it would satisfy constitutional strict scrutiny. And the main evidence that I look at in my book is very much my conclusion is that restrictions that go beyond current First Amendment law, I think, do not in fact, restrictions on so-called hate speech, I think do not in fact make meaningful contributions to equality. But if I were convinced otherwise, and believe me, I'm really open-minded about this, there's no way that I would oppose any such restriction.
Yeah, sorry. I wonder though, so this is all very helpful to sort of like as a matter of framing the discussion, but I really wonder how you are thinking about this when some of the restrictions that we are seeing now on speech, and particularly the restrictions that are that the government is looking to impose on institutions of higher learning have to do with suppressing speech that, for example, promotes, under the banner of critical race theory or anti-racism, depends on, the particular approach. We are seeing an effort from the government to restrict the academic freedom of institutions and the permissibility of trying to address matters of inequity or unequal standing among our members through engaging in such anti-racist efforts, limited as they sometimes may be, right? But good intentioned for the most part, or you might think otherwise. I'm happy to hear that. So how are you thinking about the effort that is coming legislatively and otherwise to restrict the kind of expression that is permitted on the campuses of institutions of higher learning through these efforts?
Nadine, you want to start with that one?
Oh, I was going to defer to you. We're so polite. It's clearly unconstitutional. I think this is a clear, probably the most clear example of a First Amendment violation. And let me explain why. First of all, it is the federal government purporting to deprive individual teachers as well as administrators and students of the opportunity to freely investigate, discuss, inquire, explore, debate, everything we do under the First Amendment in an open, unfettered way on one of the most important issues facing our society. And the Supreme Court has always said that all speech is important, but if we had to have a hierarchy at the apex of important speech that has to be most strongly protected against restriction, it is speech about public affairs, about issues of public controversy. And that the Supreme Court said that kind of speech, which this clearly falls into, is not only a matter of individual self-expression. It is the essence of self-government. So what is being threatened in one fell swoop or attacked in one fell swoop is individual liberty, equality, which is at the heart of what this speech is about, and democracy itself. The Supreme Court has often said that freedom of speech and open inquiry and discussion and debate are especially important in our nation's schools, because that is where we are helping the younger generation, future current citizens, to learn to develop the skills and resources and thoughts to raise their voices and become meaningfully engaged in this enterprise of we the people. And as if that's not enough, there's one final point I want to make, which is this is in some way, by trying to impose a curriculum dictated by the federal government. My goodness, that sounds like something that would happen in communist China or the former Soviet Union, not in the United States. How antithetical to everything this country stands for. But the Supreme Court has said that this kind of compelled speech, that you must be exposed only to the government-approved idea, is an even more deep and profound violation of freedom of speech than restricting what you're saying. And I guess this is double-barreled, because it's saying you can't study one thing or discuss one thing, but here's the other thing, that perspective that you have to take. And let me just remind people of the Supreme Court decision in which the court struck down that government-compelled orthodoxy. It was in a case called West Virginia Board of Education versus Barnett in 1944, I believe, an ACLU case, I'm proud to say, in which we successfully defended the right of Jehovah's Witness school children not to be compelled to salute the American flag, which was imposed as a gesture of patriotism during World War II. And even when this nation was at war, the justices struck that down with wonderful language that applies here. And I'm so sorry, I'm only going to be able to paraphrase it and not do justice to the original eloquent language, which said that above all else, we can never have any government-imposed orthodoxy in matters of politics or social or cultural debate.
So I'll start off by saying ditto. Very well said, Nadine. The obscenity and absurdity of this is so far removed from constitutional law. I mean, it's hard to sort of overstate how bizarre this is, and you have to add it with other things as well. So that the government would say, first of all, like Nadine suggested and stated, schools and universities are a special place for free speech. And the court has recognized that. And in some cases, the court has said we even defer to universities. So academic freedom is a heightened sense of freedom. Everybody has freedom, but professors have even more freedom. And professors have the freedom to even disagree with the administration, certainly at a public university. And so the fact that the federal government wants to, particularly the White House, wants to say, no, we're going to tell universities what to teach and what not to teach, and threaten them with restricting funds that they don't. secondly, it's also patently unprincipled because many people who would align themselves with quote unquote conservatives will cite federalism. And I was just reading something by Secretary Carson about not going forward with opening up the suburbs, having HUD basically say you have to build affordable housing in the suburbs under a provision in Title VIII, which we worked on and was passed on the Obama administration. And the Supreme Court has already sort of embraced it. He's saying we're not going to do that. And his major reason for not doing it was federalism. We don't want to tell cities and states what to do, but we want to tell colleges and universities what to do. I mean, the inconsistencies of it is just bizarre. And I mean, so one thing to just mention, we're in the midst of a constitutional crisis. When you have the President of the United States saying, I don't know if I'm going to peacefully hand over power after the election. And there are a number of articles today, and some of the Republicans are saying, well, he didn't really mean it. Don't take him seriously. But he comes back the next day and he says the same thing. So this is the same president's the same, and we're going to have, we don't want them teaching about racism and race or about critical race theory. And I did an interview on Time magazine. And of course, the other obvious thing is most Americans don't know what critical race theory is. So unfortunately, they will learn about critical race theory from President Trump, not from Nadine or Chuck Lawrence or Lonnie Grenier or Jeff Stone. They'll learn about it from, and it will not be what critical race theory is. It will be that you're teaching hate, you're teaching anti-white stuff. And some people will be inflamed by that, and that's the purpose. So not only do I think it's unconstitutional, which it clearly is, although you have to worry about, frankly, Trump packing the court. I hope, and I know we have at our school, I hope scholars and across the country will publicly denounce what this is suggesting. And I'm already aware that it will chill some people. It will have a chilling effect. I just want to lay one other thing out. Some of you may know that in Florida, the voters voted overwhelmingly to restore voting rights to 1.4 million returning citizens. I was involved with that. I helped reach out to Mike Bloomberg to after the legislators said they couldn't vote unless they paid off all their fines, which by some accounts is about $15 billion, which is the new form of poll tax. And I reached out to Bloomberg and others to say, this is just wrong. This is just wrong. And it'll be litigated maybe for the next 2 years, but we need to do something. And as you know, Bloomberg has helped organize paying off some of those fines. And what happens? The Florida Attorney General says he's going to investigate Bloomberg for voter fraud. Now, just to put this in context, and I'll stop, and I know you hear my frustration. We have the Postal Service talking about closing post office, removing mailboxes so people can't vote. That's not being investigated. Instead, what we have investigated is someone paying off fines, which the Florida court had said in the past that someone could do that. But now that someone's stepping up to doing it, they say, we're going to investigate them. And again, what this does is it freezes and paralyzes and chills anyone else who is thinking of doing something. That, anyway, I think we're in such an incredibly dark place in our country on so many fronts. And the curriculum, what we teach in schools, is just one of those. But none is unconstitutional. But again, I hope we'll have some activism among colleges just expressing how this is and helping explain to the American people why this is so dangerous.
If I can chime in, earlier this week I had the privilege of doing an interview of somebody whom John may know, Ellis Coase, who is a distinguished journalist and has written a number of books and has been a columnist. He was the ACLU's first and so far only writer in residence. He recently wrote a history of the ACLU, but his latest book, which he wrote in a fast passion, very quickly. The title is very long, and it has something to do with something like the curious life and swift death of freedom of speech. And I was at first surprised when I read the book because it's got a whole chapter about the Electoral College, it's got a whole chapter about the United States Senate, it's got a whole chapter about voting rights, and he never said, and voter suppression, he never said it expressly, but it dawned on me that his point, and this goes to the initial question, his point is that we don't have real freedom of speech in this country because of some of these structural problems that are excluding certain people and have historically excluded certain people from full participation in the civic enterprise. If you are denied a vote, what is a more profound way and more bedrock essential way of raising your voice than through voting? And that really opened my mind. I thought, freedom of speech is not only about the First Amendment and the 14th Amendment, as we've already described, but it's about every other element in our governmental structure that we have to attend to if we are going to give meaningful, equal, effective voice to everybody in this society.
Great. No, that's so important. And I guess, a lot of colleges and universities, including Penn, are worrying now whether the fact that we are, in fact, teaching critical race theory in some of our classes or requiring anti-racist training or even a bias awareness training for various members of our community. Does that mean that we will not, as an example, right, that colleges like Penn and universities like Penn will not be eligible for federal funding based on this executive order? What is your understanding whether this executive order really is able to suppress the curricular type of expression for institutions?
Well, again, I think it's pretty clear
Please.
that it's unconstitutional in any reasonable reading of the Constitution. I'm not sure we'll always get a reasonable reading of the Constitution. I don't think it's not a close case. There's some things that are nuanced and we don't know exactly. This is not one of them. This is really clear, but it's also really clear, frankly, that the White House doesn't care. I'm sure you've seen the thing where President Trump is talking about he may see if he can negotiate a third term. Where does that come from? And I think he's betting that that people will fall in line, that they won't oppose him, and if they do, he will just bulldoze them, and they'll have his judges. So that's why I say we're in a constitutional crisis. It's hard to just sort of focus on one thing, but I do think it's important to stand up. We as institutions have more power than our individual faculty members and our individual students. And if we do stuff together, we have more power still. And I think we need to actually use our standing in this country to not just defend ourselves, but to defend academic freedom, to defend the bedrock of our institutional structures. And if we fail, the country's in trouble. It's not just the universities in trouble, the country's in trouble. So I would implore us to be all in on this and to devote some resources. And it's not what we teach, right? It's the fact that the White House can't be dictating us to say, we want you to teach Americans how to be patriotic. What the hell does that mean? I think critical race theory and anti-racist training is patriotic. I think Lincoln would be proud.
Thomas Jefferson famously said, dissent is the highest form of patriotism. And on John's point about how everybody in this country has a stake in robust academic freedom, even the United States Supreme Court said that in one of its first cases recognizing academic freedom as implicitly protected in the First Amendment, and said the beneficiaries are not just those who are part of the campus community. Our entire society really depends on that. Now, that said, I think it's really important to amplify on something that I think I heard both of you allude to, which is that there should be no orthodoxy about or indoctrination about any of these courses or how they're taught or what material is used. So I have heard some complaints that there is a requirement to use the so-called 1619 project, and that people are afraid to criticize it or question it, as some historians have done about some aspects of it. That would be equally problematic for a number of reasons, not only because of intellectual freedom concerns, but if you're attempting to indoctrinate somebody, that's not an effective way to persuade or to educate. If you really want people to understand and grapple with and be dedicated to overcoming and fighting a history and a present reality of racial injustice, they have to come to that voluntarily. Otherwise, it's just going to have a negative, adverse impact.
So Nadine, I agree with you in spirit. There's one caveat I would make. I wouldn't say it's problematic, but it's not equally problematic.
Yeah, that's true. That's
You know,
really true.
I was on a
Because
call
it's coming
today.
from on high, Commander-in-Chief. Yeah.
Exactly. So, I mean, there's complicated stuff. So I think, for example, reparations is another very complicated question, and I raised some complexity on a call today. But when I raise that, it's fundamentally different than the White House raising it. And I can't withhold anybody's money. I wish I could. So there is a power differential. So when it comes from the White House and members of Congress, government, it's of a different order.
Absolutely. And even if it could not be enforced, a lawsuit is brought to challenge it, as Segal already indicated, it's going to have a chilling effect, and that may well be the intended purpose. So what if it ultimately gets struck down in court? Trump can say, meanwhile, I'm going to have all these people actually changing their behavior.
Great, so true, and definitely concerning. And as John was saying too, really interrelated to a lot of other concerns that people may have about the chilling effect of various decisions and actions, including the ones, Nadine, that you mentioned regarding voting. I want to bring into the conversation Matt Schaefer, who is our postdoctoral fellow this year, and with a question that he wanted to raise to our speakers. Matt, go ahead.
Thanks. So this is in slightly different direction, but on another end of current events. We're having this conversation on Zoom right now. We're all really comfortable on Zoom. We've become comfortable on Zoom over the past 6 months pretty quickly. And I think we're so comfortable on it now that it's easy to forget how dramatic of a transformation this is to the routines of our sort of everyday public and private ways of speaking and communicating and participating in discourse. I think the pandemic has really accelerated what was an ongoing shift to more and more of what we traditionally would have thought of as like public political conversation happening on digital platforms. And although I haven't seen anything yet in the news about Zoom administrators censoring like Zoom callers directly, although maybe there is some that
There is.
I'm not well enough informed of that. But there was a pre-existing conversation about the role of moderators and administrators on platforms like Facebook or Twitter or other social media, where there's huge sort of extremely opaque, bureaucratic and quasi-juridical apparatuses in place to moderate what kind of speech can happen on the platforms. And so with this kind of like privatization of the administration of speech regulation and this kind of rise of platform governance taking on more and more of the traditional functions of like the governance of the public sphere, how should we think about the way that we need to rethink our understanding of First Amendment principles to this new kind of like public space, especially now that with the pandemic, this has gone hand in hand with like a change in the relationship between First Amendment expression rights and First Amendment assembly rights.
Do you want to start, John? And let me predict the first sentence, which I concur in. This is extremely complex, perhaps even more so than everything else we've already talked about.
That's true, so yeah, it is. I mean, I live here in the Bay Area, you know, there's first of all, obviously, most of the tech companies and all of them really are not public in the classical sense. We still have a public-private distinction in law, and it can bleed into each other. We used to talk about whether or not shopping centers were public for the purpose of free speech. People, under certain conditions, you could say if everyone was invited and whatever, even though they were privately owned, it started to look like public. Other people, no, it has to be formally public in order for it to be public. So those are some of the questions no one quite anticipated. And this is part of the living constitution. No one quite anticipated Facebook with I think over 3 billion members, Google with over 1 billion. They're bigger than most governments. There's only a couple of countries that have more than 1 billion people, China and India being the two. And people use that to not just to come together, but also sometimes to do pretty nefarious things, you know, like post pornographic pictures of their ex-girlfriend or boyfriend, to psycho-bully, to steal elections. And in a sense, the growth of the tech world has been so fast and so ubiquitous, we haven't kept up. We don't know how to think about it even. I met with the head of Twitter. They were saying they're trying to capture, for example, they're trying to capture extreme incendiary things on Twitter. They said that they cannot do it. We're, like you mentioned, Matt, we're on Zoom, but it's not really a public platform. In a classical sense, no one can just walk on to this. And if they could, you probably would be very uncomfortable. You know, the Zoom bombing, someone walking in your class, is this more like a class or public, naked or making obscene comments? So part of the thing I think that we keep coming back to is that the world is changing so fast, and we really have to stretch sometimes to take concepts like public forum, and a lot of the background assumptions simply don't work anymore. And yes, we're all on Zoom, and I have, Nadine and I were talking about earlier, I have a granddaughter, she's 11 years old, she's on Zoom too. That's how she's in school. Well, Nadine made the point earlier, if you don't have the capacity to join the public forum, how do you have free speech? How can you participate? And I've written an article basically saying, the gist of it is that it's not equality or liberty in the narrow sense that's a fundamental right. The fundamental right of any democracy is participation and belonging. And out of that, all the other things flow. Now, speech and equality are critical to participate and belong. But you have students all over who don't have access to the computer, don't have access to the internet. They can't participate. If that's how we're conducting business in terms of schools, in terms of discussion, and we have large numbers of people, and it's deeply racialized, it's deeply associated with income. And this is apart from Facebook and Google monitoring and moderating it. They just create a monetary standard. And then the information on Facebook and Google and other Snapchat and others I haven't even heard of, whose information is it? And so you have the whole issue. One of the last things I did at ACLU was sort of look at this sort of privacy issues when the question was, if someone was on Facebook, have they given up all their privacy rights? And that was a question we grappled with at the legal department. It's like, we hadn't thought about it that way. It was a very new concept, and that was 20 years ago. So what I would say, Matt, is I think it's important, not just in terms of First Amendment, but in terms of all these issues, just to really look at what's going on in the world, really try to understand it. And then, of course, the whole thing of national boundaries. So there's a national boundaries issues for many things. There's not for these internet platforms. So what if the Russians want to join the call? Can we tell them no? We have election law that says foreigners are not supposed to influence our elections, but we have these platforms where there are no boundaries. How do we manage that? We don't know yet. And so I think these really are important questions, but I think we should avoid simple answers.
In the past few years, I really have been trying to steep myself in the issues surrounding social media. And as Matt no doubt knows, there has been a wonderful outpouring of really great creative scholarship and a lot of thinking about what the challenges are and some potential solutions. So that's the good news. And I've even been in touch with a member of Congress who impresses me very much. She's from Silicon Valley, Ro Khanna. You may know him, John, who's been doing a lot of very serious thinking about these issues. But I can just tell you what I would, there are some simple answers, Matt, which is, I think, government taking over the content moderation function, as to some extent the Trump administration is threatening to do. I don't know if you saw the proposed legislation that the Attorney General sent to the President, to Congress a couple of days ago. I think that's even, well, it's sort of like 6 of one, half dozen of the others. Do I want my free speech right to be hostage to Mark Zuckerberg? Or do I want my free speech rights to be hostage to Donald Trump? This is not a very appetizing choice, and it's a nonpartisan comment. I wouldn't want Joe Biden to be in charge of my free speech, or any other corporate titan as well. There are, and let me give you one really troubling example, which I think Sigal is aware of because I saw her nodding. Recently, like in the past couple of days, I haven't had a chance to investigate it, but I saw that Zoom had reportedly refused to allow its platform to be used for a university that was hosting a speaker with what Zoom considered to be not only a controversial position, but one that didn't deserve a platform at all. And it had something to do with Israel and Palestinian rights. Sigal, you may know. Do you know the details of that example?
Yes, I do. This is the University, San Francisco State University. Two faculty members there have invited Layla Khaled, who is a member of one of the pro-Palestinian groups that is deemed by the American government to be a terrorist organization. And she herself was participated in 1969 in the hijacking of a TWA flight, which I know about because it had an impact on my own family. She never disavowed the use of violence and remained a member of this Palestinian Liberation Organization. She was invited to speak about Palestinian rights, which obviously has its own complicated legislative context, right, in recent years, and which I think is itself very problematic. The legislative effort to suppress pro-Palestinian speech are very problematic in themselves. We have an event about this later in the semester as well, to discuss the boycott movement and its suppression of open expression on campus. But Zoom has decided that they are not going to allow the use of their platform to host Layla Khaled, which, is a first, as Nadine was saying.
But probably not the last. And Matt, let me tell you, where even as a civil libertarian who recognizes that these private companies, as engaged in communications, have free speech rights, just along with the New York Times or Fox News, to decide who does get a platform and who doesn't have a platform. We have to find other tools to encourage them to, or to pressure them to not discriminate narrowly on viewpoint. Although that said, I think that they certainly do have a right, and I understand the business impetus to not allow hateful speech, because that will drive other people off the platform. So even though I wouldn't want government to censor any more speech than it does already, I understand that it's different in the social media context. What really, really troubles me, and where I would like to see some government regulation, is on basic procedural type matters. Transparency, accountability, notice, due process, privacy protection. We don't have any of that. From what I read, it seems to me that we have surveillance capitalism that is gathering just unfathomable amounts of information about us, and then using that information to doctor the results that we get, the information that we see. And I consider that to be a form of thought control and manipulation. When we lose individual freedom of choice about what we see and what we say, but we're subject to manipulation by algorithms, that is completely inconsistent with individual liberty.
Yeah, just as one, I completely agree. And I mean, just signing on to the internet, right? And they say, we have cookies to collect information from you. And I mean, it's like, why do I have to keep saying that? You know, it's like, I don't want you to have my information. Why do you need my information? I'm just trying to look up an article. And sometimes if you don't give it to them, you can't get the article. I mean, so it's their power, their reach is something that we have not, you know, like Nadine said, it's complicated because you don't want Mark Zuckerberg deciding, you don't want the president deciding, but you have these huge platforms that keep getting bigger. And then and not just for us as professors and adults, but for kids, you know, 10-year-olds, 11-year-olds. It's a very different world.
Yes.
Thank you for your eloquent remarks. Nadine, I wanted to ask you a question about a distinction that you raise within the university, building off of a concept from Howard Gilman, who was our speaker last night, and his co-author, Erwin Chemerinsky, about professional campus speech, the speech that is done by professors and other administrators of the university, as opposed to the speech of students and outside speakers. And you make two interesting remarks, I think, about this category of campus speakers in the essay you provided. On the one hand, you say that it's consistent with current free speech principles that there be more restrictions on what professional campus speakers say, that hate speech, which might be more allowed among students and outside speakers, could be regulated if that speech is inconsistent with the university's mission. But you also say something different, which I would also like to hear about, which is that this doesn't mean that materials, curricular materials that have hateful speech in them should be removed from courses, that they can not just be allowed as a matter of rights, but you say that they can be educationally important. Mm-hmm. And so I guess I'd like to hear just a little bit more about that distinction that you're supporting between the professional campus speakers and other campus speakers. And on the one hand, the more stringent regulations upon professional campus speakers, but also your view of, so maybe a little bit more like an example or two of how otherwise hateful language could actually be educationally important when well presented in a classroom.
Okay, well, let me just thank you so much for that, Jeff. And I was very happy to watch the really enlightening exchange between Sari Banks and Jeff Gilman yesterday. Howard Gilman, and I had read his and Erwin Chemerinsky's book, and I found they were the first ones that presented to me that distinction, which I found very, very persuasive. And in some ways, it has to do with the distinctions between academic freedom and free speech, which Jeff Stone was also talking about. And I also watched that and enjoyed it. So this has been really an intellectual delight for me. But basically, if I as a professor, and it has to do with deference to a large extent to individual professors, but also deference to other decision makers within the university. So a department chair or even a higher level university official. Setting the curriculum is something that is not a matter of letting all, everybody who wants to teach anything can be part of the curriculum. Likewise, setting the syllabus for a particular course. You have to be selective. I think that's the concept, Jeff. You have to curate. And that doesn't mean that you're discriminating against something on the basis of ideological viewpoint, but you're making a decision that this particular course or this particular item in the curriculum has more pedagogical value than an alternative material that I'm not including. And you have to judge that is a professional judgment. It is based on the content of the material. Sometimes it's based on the viewpoint, right? If you're teaching geography, you're going to discriminate against a text that has a flat earth viewpoint, right? Although I agree with the Supreme Court that there should not be narrowly ideological viewpoint discrimination. So to take an absurd example, in a con law class, you may agree with the majority or you may agree with the dissent, but you're going to assign both opinions to your class. And that's a very good example, Jeff. Unfortunately, we had an instance recently where a law professor was really pilloried and excoriated and apologized profusely for having his students read a great classic case of First Amendment law, and another ACLU case, Brandenburg versus Ohio, which involved a bunch of KKK demonstrators. And guess what? They used the N-word, and the Supreme Court, in its opinion, quotes what they had said because they were punished for their expression under the Ohio law that the Supreme Court struck down. And I think that was completely pedagogically not only justifiable in my viewpoint, it would be essential for the students to understand exactly how ugly the message was, to understand exactly what kind, degree, and scope of free speech the Supreme Court was upholding. And there are many other examples. I spoke recently at a college where the professor who came to my talk was very shaken because she had just been attacked for having assigned Martin Luther King's famous letter from a Birmingham jail, and she was having the students read it aloud, and in his letter he uses that word at least 2 times, maybe even 3 times, and the students really got very upset and were very hostile toward her. To me, this is another example where it's pedagogically justified. But the reason I started by saying we should defer to the professor's judgment, I think it would be complete, and I know people are going to disagree with me, that's fine, but I would understand if somebody made a different pedagogical judgment, which is that it's so fraught now, especially in these, and you may make a different decision from one day to the next. You know, what John referred to as the terrible trauma that his students are experiencing now, and students all over the country, we may make a very different decision today from what we may have made a week ago. And I think that should be, the kind of judgment that we have to entrust our conscientious faculty members who have the best educational interests and interests of well-being as whole people for their students in mind. But I would oppose a categorical ban on ever including that word in a classroom context.
Great, and I think I have heard from our colleague Sari Banks, who spoke here earlier in the conference. In a previous presentation that she gave, she actually made a very similar consideration where she talked about if I remember correctly, about the Teaching Randall Kennedy's book, whose title has the same word in it. And she said that students have different responses to her as an African-American woman teaching this text than they have sometimes to other professors, but also students over time respond to it differently. And so just sort of channeling Sari here, who I think, if I understand her correctly, would agree, Nadine, with your point about being sensitive to the time and the context. And I see we have another question coming from Amy Seppinwall. Go ahead.
Thank you. So this has been really wonderful. I so appreciate the very nuanced approaches that each of you has. And it's also been really inspiring to see how great the convergence is between you. But I think I want to press on a place where I suspect you diverge. And this picks up on something that Nadine said. So at one point, Nadine, you were quoting the strict scrutiny test, and you said that you fully appreciate the compelling nature of the interest in, let's say, combating racism, and you would embrace speech restrictions so long as they were necessary for achieving the end of combating racism. And I suspect that the two of you might disagree as to what rises to the level of necessity, and as a way of maybe motivating the thought that more speech restrictions than perhaps you, Nadine, may be comfortable with might be necessary. I want to advance a line of critique that I'm sure you've both heard and to which you both have responses, but I'd be really curious to hear what those responses are. So in the sort of Catherine McKinnon, Ray Langton vein, one might worry that some speech is so derogatory or so denigrating that it in fact silences the target of that speech, such that we can't count on the target of that speech being able to marshal counter arguments with the same force or authority as the original speaker. So would that be the kind of case that satisfies the necessity condition, right? That makes it permissible to censor or limit in some ways the original speech that has this very damaging quality, or not? How should we think about satisfying the necessity condition?
So if I may start, John, Amy, current law already does allow much hateful speech, especially if it's targeted at an individual who is a member of a traditionally marginalized group, allows it to be suppressed. So if, for example, and Jeff Stone actually mentioned a couple of these in his talk, if it is a so-called true threat, or if it is targeted harassment or bullying, or if it's intentional incitement. So and if it's part of an assault, it can actually be punished as a so-called hate crime or bias crime. But you have to look at the context. You have to say, if in these facts and circumstances, the individual feels the targeted individual has a reasonable fear that they're going to be subject to attack, or has her freedom of movement circumscribed, then it can already be suppressed under current law. Where I would oppose going further is if we say, even if you can't show that direct causal connection between speech and imminent harm. The fact that it causes, and here I think John and I have disagreed in the past, so why don't I use this example? It causes emotional distress or psychic distress. I would still, I'm open to persuasion, and I'm considering it, I have considered it. I still agree with the Supreme Court that that psychic and emotional trauma, real as it is, and despite the fact that it certainly has physiological manifestations and speech suppressive manifestations, I completely agree with you, Amy. You know, so you have speech on free speech concerns on both sides, and I've experienced it. I've been subject to hate speech, and you know, the immediate impact was to stun me into silence. So I empathize with that. And the only reason why I don't want to expand the definition of punishable speech is that I distrust the powers that are going to be exercising their discretion to punish speech. When I think of all of so in other words, I think it's more harmful to give the government more latitude. Until quite recently in our history, we had the so-called bad tendency test. It wasn't until 1969 that the Supreme Court adopted the strict scrutiny test. And before that, speech could be punished if it had a tendency to perhaps cause harm, including emotional harm. And under that looser standard, that was what was used to suppress every kind of dissident and crusader for racial justice and gender justice and so forth. So I think we have to be very attentive to the harmful impact, but I think that non-censorial methods are the best way to deal with it. I just read an article today in Psychology Today. I've read many such by mental health psychological experts who say, you know, the best thing we can do for people's mental health is to instill in them the habits of resiliency, and that there are techniques that we can train people so that they do not allow the disparaging words to actually have a negative impact on them. So if the necessity test would not be satisfied if these other methods worked. But if John and others can convince me that they don't work, that they can't work, I would be open to recognizing that there's harm, including harm to free speech.
So I think Nadine and I have discussed this before, and she discussed this in our book. And I'll start, I think there's some different application, much more than different principles. And the earlier question the Segal asked about in terms of absolute, when Nadine doesn't take that position, I don't take that position. If you look at early debates, and Lee Bollinger and others will acknowledge this, that the early debates was to minimize the harm that speech could cause. And that goes all the way back to Mills. Mills started off by saying, you know, and the early courts, that the harm associated with speech was to minimize. And so it was seen as an individual right because it had almost no capacity to harm, or the harm was small. And there were a few exceptions, but that was where we started. And so we had essentially 100 years where that was the predominant jurisprudence. And to be honest, I think we're still suffering from that. And only in the last, I don't know, 30, 40, 50 years have we started to actually say, well, maybe there is a harm, and maybe the harm is not de minimis. And how should that affect our thinking? And so I don't start off in that sense from a positive position in terms of this is what the court said. You know, I mean, we talked about Justice Ginsburg, and she said, when the law is wrong, it's time to organize. Sometimes the law is wrong. And I think, I mean, I do a lot of work in this. For example, and this is not just true of the United States, if you have a society that's organized around a certain set of principles, excluding women, for example, excluding people with disabilities, when you first start opening up to women and people with disabilities, you do it through the prism of an all-male, able-bodied society. Everything will be distorted in that way. And all the work in terms of the adjustment will be on the people who have been formerly excluded. And people won't see anything wrong with that because those early norms will be seen as just, that's just the way it's always been. It's like, okay, let's now make some minor adjustments. And sometimes those minor adjustments for the dominant group are huge adjustments for the group that's been excluded. And I'll give you a concrete example. So if you go back to the early cases of women coming into the workplace, when they first started coming into the workplace, literally in many of the workplaces, there were pornographic picture around the wall. And this issue went all the way to the Supreme Court. For the first couple of years, those issues were in the public discourse. The argument was, well, this is always how it's been. And and the women need to adjust. And then the next argument, frankly, sometimes advanced by the ACLU, was the way you deal with bad speech is more speech. So if there's pornographic pictures of women, the women could put up their pornographic pictures of men. In my mind, a crazy idea. We also go back to Oliver Wendell Holmes' famous marketplace of ideas. And yet we're in a place right now where people are seriously questioning how the market works. You know, so when Holmes suggested that, we more or less was sort of like this belief that the market does certain things through the invisible hand and give us this fair chance that we'll sort things out. I think fewer and fewer people are believing that now. And so what I'm saying is that a lot of our thinking, and you probably know Lakoff's book, Don't Think of the Elephant, he said we think in metaphors. A lot of our metaphors actually don't work. And so if someone hits me and I hit them back, we both have been injured. So it's not clear that always the solution to not just offensive speech, and I give Nadine credit for harmful speech, speech that really harms. And once we acknowledge that this is harmful speech, again, going back to Mills, we're back into the solution of saying, these are social rights. These are social liberties. I don't have an individual right to injure another person. We may come to that conclusion for some of the reasons Nadine suggested. That is, maybe the alternative is even worse. That is, we give the power to government and you find out we didn't fix it, we only made things worse. That's a social argument. That's not an argument that I have a right to say and do whatever I want to and the government can't interfere. It's basically saying it's a very different argument. And we haven't engaged that really. We haven't really talked about speech as a social right as opposed to as an individual right. That's a fundamentally different way of thinking about it. So the question you asked, Amy, which I think is a great question. Again, I would say, go back. Now let's have that discussion in the context of what we're understanding about harm and how not just short-term, but long-term harm speech can actually inflict. Do we want to allow that? Now, Nadine, your point is like, well, maybe the way to do it is to help the victim to recover from the harm. But you could say that in anything. I go up and touch some stranger on the street and say, well, have the stranger go to a psychologist and get over being touched on the street. And just so you don't think this is hypothetical, I lived in Tanzania. In Tanzania, if you're in line, the person behind you will touch you. When I first got there, it's like, ooh, you know, my personal space is being violated. Now, the good news is it's not sexual, it's not lewd, but they have a different sense of personal space. And I was so, I probably shouldn't tell this, but I will. So after being there for a few years and coming back to the United States, I'm in an interview. And the guy, you know, interviewing for a job. Actually, anyway, at some point, the guy seems to be getting along famously. It looks like I'm gonna get the job. And the guy reaches over and touches me on the thigh. My first reaction was, oh, this guy's been in Tanzania. I didn't pull back, I didn't say anything. It was only later I realized he's actually hitting on me. So, but my point is, and I said this actually to the Berkeley yesterday, because they talked about getting the students help who are traumatized by what's happening. The students raised some things and the professors, from my perspective, weren't in a position to deal with it well. And the response was, how do we help the students through these traumatic moments? Maybe we should hire therapists to come in. And I was saying, think about it. Think if I come to you and say, in my community, and they show this, whenever a Black person is killed, for the next 2 to 3 months, the entire Black community suffers measurable harm. Okay, so is the solution to that to get a therapist to go to the Black community to reduce that harm? I don't think so, because you're still leaving the reenactment of that harm and the right, in this case, of the dominant society to conduct that harm. And you're basically saying there's something wrong with you because you can't process the harm in a healthy way. And I don't think there's a simple solution, but I think it needs to shift a little bit. And if we are as societies going to say that the women or the blacks or the people who are disabled going to have to bear the harm for the good of society, should they be compensated for it? If they're doing this social good, how do we actually say to you, thank you for helping us, function as a society? So I don't think we've had those discussions. I think that if we have those discussions, I'm not sure how they come out, but I think they may come out differently. I think one of the things, you're inviting people's voice into the conversation in a different way. And then the last thing I'll say, and this happens at Berkeley as well, because we've had a lot of these issues, go back to our opening discussion. And that is what we say, equality and participation are of equal paramount values. And we're saying that maybe in some instances, speech is actually truncating both those values and free speech values, including the value of autonomy. Then I think it's up to all of us to see how can we reconcile those, and not to start off by saying, unless you can show me that the harm is long-lasting, serious, whatever, then we have to put up with it. And again, just remember, when women first came into the workplace and their boss would touch them and they would complain, that was the response. You, woman, it didn't mean anything. So you have to carry that burden. No one would say that today. So we've made some shifts, and I think it was a good shift. But I think we're still doing the thing in terms of speech. It's like, black person or Palestinian or Jew, you just have to put up with that. Don't be so sensitive. Don't be a snowflake. And myself, I feel like I have not been overly traumatized. Maybe not, sometimes I feel like I'm a little dense. But still, someone should not get the benefit of my density, right? The fact that I'm not traumatized. And we're talking about, I would say, not individual harms. We're talking about group harms, like evidence in terms of what happens when there's a killing of an unarmed Black person, the impact on the community. And I've talked to health people about this. We still have not figured out a way to respond to that. And it's going on all the time.
Well, John always expands my thought and makes everything even more complicated than before, and I very, very, very much appreciate that. I do agree with you, John, that the Supreme Court's discussion in the cases about intentional infliction of emotional distress is not persuasive. It doesn't go into enough depth for my satisfaction. But I think what's really important is that we bear in mind that, the egregious forms of face-to-face insults, I think pretty much those can be dealt with by existing and justified exceptions to free speech. What really worries me, and here I'm getting to a distinction that Howard made yesterday, when we're talking about something that conveys an idea, right? It can be an idea that's controversial. It can be an idea that seems insulting. But that's what we've had a lot of pushback on campus, that certain ideas about matters of public policy, such as immigration or police reform, that people are genuinely upset and can see an advocacy of a certain policy position or an opposition. People have been attacked as racist for opposing the notion of defunding the police. And I have no doubt that there are some people who feel deeply hurt and harmed by those ideas. But this is where I think that from a societal point of view, it may well do more harm than good to extend the net that far. And so then we get into the old challenge of, can we come up with a definition that does not end up punishing? I'm going to quote our former ACLU colleague, Eleanor Holmes Norton. She said, nobody can come up with a hate speech code that doesn't punish ideas we all think should be protected. It has been tried and tried and tried. Well, there's no reason we shouldn't keep trying, but that's to underscore how daunting the challenge is.
Well, so again, I think we have a deep resonance, but I think the application, interesting. So here's one thing. These are all real cases. There was a professor at Berkeley who did something and the students called her racist or whatever, and she fell apart, she started crying, and then the faculty had a meeting, and their meeting, and they said some of the things you just said in terms of like, and they wanted to reprimand the students. But think about this. In some sense, they're saying the students, now they didn't touch her, they didn't hit her, they didn't slash her tires. They're using speech. You know, okay, on one hand, we're saying you should be able to use the N word, but you can't use the R word.
No, you can. You certainly can.
But no, what I'm saying is that the powers that be rallied around the professor because being called a racist and somehow was much more serious than using the N word. And they were ready to shut the students down. And I said, "Oh, stop the train." If we invite someone to campus, and I say that person's a misogynistic racist, that somehow becomes almost beyond the pale. But the person saying, anyway, I'm just saying that sometimes it's not even-handed, even when there's a power differential. One of the events at Berkeley that I know of, in terms of a person coming to talk about immigration, it wasn't just talking about immigration, it was trolling people. And the person had indicated that they actually were going to have the list of names of students who were undocumented and expose those students to ICE. And also, again, remember, we're in a quasi-authoritarian space. There's not oftentimes a serious effort, I'm not saying this answers the question, of finding the truth, or having a discourse, that sometimes the very purpose of the speech is to injure. As our friend Elena Kagan has said, speech has been weaponized. And if we don't at least acknowledge that, it seems to me we're making a hard situation too easy. And anyway, so I just think that, yeah, they're hard questions and they're going to become maybe, unfortunately, harder. And I think one of the good things from my perspective is that as people who have been historically marginalized, historically from these discussions come in, they're going to come in with different perspectives. They're going to challenge some of the assumptions. And my chancellor, who I have a tremendous respect and admiration for, I was a little annoyed when, after all the stuff happened with students and faculty around speech and equality, we decided to have a year on free speech. And I said, what happened to equality? You know, it's like, what happened to participation? What happened to affirmatively saying to the students, we are going to we're going to affirmatively engage the probability, the need to create a space where you feel not attacked. And many of these students that we get, and it's one reason I enjoy teaching at Berkeley, do come from immigrant backgrounds, do come from backgrounds where they've seen horrendous stuff happen. So it's not abstract to them, it's real. And again, I don't think the answer is to tell them, you know, toughen up.
I hope I didn't sound that dismissive. I know you. And if I just want to make
sorry, Nadine. Just I'll give you the microphone back in 1 second. I just want to recognize that we are past our time, and so I just want to mostly apologize to the people in the queue whose comments and questions we didn't have a chance to take up, specifically. My wonderful doctoral student, Jasmine Blanks-Jones, who is raising some issues regarding the efforts in the African American Studies program that she's a part of to read against racist texts or to read against texts that are problematic as in an effort to learn more about silenced voices. And another comment from Sean Kelly about the reduction in trust in higher education institutions and the context of censorship around this, or the effort to tame, so to speak, our curricular offering around this reduction of trust. And so we didn't get to those, but I do want to conclude this conversation, Nadine, with your comments. So after this quick recognition, please do offer your
Oh, I
response.
really want to self-censor if we're out of time. It's been a wonderful, enlightening opportunity, as it always is when I share the platform with John. And on the point of, since we're paying so much attention to speech and the power of words, I'll just trade something. I hope you don't mind, Sigal. You had originally written an email to John and me in which you referred to a debate, and I really bristled about that term. And quite frankly, I don't like the battle term that's in your overall conference theme, because I really think this is not a matter, it's not a binary. I mean, there are a zillion shades of gray and nuances and complexities, as all of the speakers have, and the wonderful questions have elucidated. So it's just been a fabulous learning experience for me, which is going to fuel my continued thinking. And thanks to all of the wonderful questions as well.
And so if I could just quickly chime in, I agree with Nadine. And so two things. I think about Habermas and Irish Young, when they talk about ideal speech situation. What do you need to have real bridging? How do you really hear someone else who has a different perspective? I think that's really, really important. I think we're losing that, both in college and in society at large. And I don't think we pay enough attention to that. It doesn't happen automatically. And one of the reasons I value these conversations with Nadine, I don't think of our bridging as the bridge is very short, because we do have a tremendous respect for each other, and I learn from Nadine. But also I like the idea, right, of not doing a debate. It's like, let's look at this together. I'm going to seriously consider and go back and read your stuff again, because I am opening to learning from you, not just to hear from you so I can refute it. And I think that we've gotten into, especially in law, into debate and scoring points. And I think that's actually, on the long run, counterproductive. So I want to thank Nadine and all of you for being able to spend time with you.
Thank both of you so much, and we will take somewhat of a longer historical arc maybe when we have our concluding panel Tuesday evening at 5 o'clock, looking historically at the development of the concept of academic freedom within the discussion of free speech, and how universities are attending to this matter today in light of some of these societal changes that you both so wonderfully elucidated. So I really want to thank Professor Nadine Strossen, Professor John Powell, for your enlightening words today, and for engaging so thoughtfully in such a fraught area of thinking and acting, despite some obvious, or maybe because of some obvious disagreements. Thank you all so much. I hope you have a good weekend. Thank you for spending time with us, and thank you to Jeff and Matt and Amy and the rest of the participants.
Thank you.
See you soon, I hope.
Thank you. Be well.
Bye-bye.